not answers. The office was going, so don't expect any answers. Okay, in the announcement that you got, this is what we're sending out to everybody, starting now. So every letter that goes out has this announcement in it. And what it explains is we do have a new law going into effect, and anything registered after January 1, where the whole work comes in after January 1, it's going to call for a new application form, a new fee, $10, and meeting the deposit requirements of the new law. And the basic principle is if you send something from scratch, application copies fee, after January 1, it has to be a new form, has to be the higher fee, and has to meet the deposit requirements. If it's pending now or before December 31st, how you decide the classification is going to be whether or not what we have now substantially meets the requirements of the present law. And they've got some transitional guides. For example, if today we have a letter saying, I want to copyright my song, have a copy of the song and a $6 fee, they say the letter is almost equivalent to an application. You have basically the three items. We will send a Form E, and even though that comes in after January 1st, we will register on the Form E with the $6. And we're going to run 2 classification systems for 6 months. The old classification system will run all the way to June 30th, 1978. And it's going to mean examiners are going to have to be careful when they send out the right form. The basic rule is if you've got all 3 elements today, you can register on using the old forms and the old fee. But if you're missing an element, let's say it's a published work, and it says 2 copies, and you send us Form A, 1 copy, and $6. You didn't send the 2 copies, therefore if it comes in after January 1, it's going to be a TX with $10. So I think you can guess there's going to be a lot of correspondence. Okay, the new classification system. Most of you have looked at this in the class that I had before and in the announcements. 5 basic classes. And they wanted all new letters so there wouldn't be any confusion. There's going to be plenty of confusion, and they thought we don't need it in this area. So you have a class TX, and when we go through the forms, we're going to use a TX form because that's more complete than any of the other forms. And I'll tell you what is different in the other forms. But the TX has more spaces and more things to fill out, which is why we're going to use it. So the TX is going to cover all types of literary works. Fiction, nonfiction, poetry, periodicals, textbooks, reference books, compendia. All of the serials, periodicals, are going to be in TX. And the examining division is reorganizing, I guess, as you are. And they're going to have a literary section, and all of that periodical unit is going to move from arts into the literary section. Second class that they came up with was a PA. This is for the performing arts. And it's supposed to be for music, dramatic works, choreography, pantomimes, motion pictures, audiovisual works. And audiovisual works include film strips. Also, they made a decision that a poem, if a poem comes in Class PA, you're going to accept it because many times poems are intended to be recited. So they're going to let poems go through PA if that's what comes in. Then there's a VA class, and that's for the pictorial material, the sculptural material, globes, chops, maps, technical drawings, models, diagrams. One thing you're going to notice is when we get to the deposit requirements, we are not going to accept any 3-dimensional objects for deposit. So you're going to be getting photographs. Under the old law, it was optional. Send us the 3-dimensional object or a photograph. New law, you must send us the photograph. We are not going to be storing 3-dimensional items. Okay, the 4th class is a sound recording class, and that's pretty much as it is today. It's going to have its own class. What was Class N will now be Class SR. The only difference is today, if you get a multimedia kit, you say that you have to have an SR application, or well, an N application and an A, or an N and a J, and you're only going to have 1. Also, the new law says that sounds accompanying a motion picture or audiovisual kit are not sound recordings. So if you have a booklet in a package, and with that booklet you have a film strip and a cassette, the cassette isn't going to be a sound recording. It's going to be sounds accompanying an audiovisual work, the kit. And that is going to not be a sound recording, but a part of an audiovisual work, and it's all going to be registered in Class PA. And that's a change. Anyone have any questions so far? Okay, the last class is a renewal class, and that It's just like today we have a separate class. And the forms for the renewals, by the way, look very much like the present forms. They figured that form worked. We really don't have to change it. Why change the basic format of it if we don't have to? Yeah, Warren. No. This office did not want to force anybody into saying we will only take one, because for some reasons they might want separate registrations. Partially because when they go into court, the issue is, what is the work and did you substantially copy the work? So some people want to split the work up, so when you just take the sounds, they say they took the whole thing, as opposed to saying, look, we only took the sounds of this great big kit, and that's not a substantial amount. So no, we said, you can register it on one, but if you want separate registrations, you can. If the owners are different, you must register it separately. It's kind of like today. You can only register on one application that which one person owns. So if you have, let's say, one company owning the sounds and another company owning the literary material that's on it, you're going to have to do 2 registrations. Anyone else have any questions? There's going to be very few wrong forms. The basic criteria is if anything that you've got before you can fit the classification that they have picked out, we're going to let it ride. And so they made decisions like, if you have a textual description of choreography, it's really a choreographic work. However, they file a TX. Since if we wrote, we'd rather have it in class PA, but if they say no, we're going to allow them to put it in TX. We've decided that we're not going to write in the first instance. We'll take it in TX if that's what comes in. Or if it's an avant-garde musical work, and there's no musical notation, and it's described by words, it really is a musical work, and we prefer class PA if we're asked, but if they come in with a TX, we'll let it go. And I guess the catalogers are supposed to pick up the fact that this is a musical work and have an indicator to show that it's a musical work, so even though it's registered in TX, it can be printed out in the music catalog or part of the PA catalog. So it's going to be kind of tricky. We're basically saying that if it fits at all, we're going to let it go. Wrong form. It's got a globe and they're registering it in class PA. Wrong. There's no way that it can be a work of the performing arts. A book and they have it in class VA. Wrong. It's not a visual work unless there's illustrations. But if there's illustrations, we'd let it go on a VA, even though it's preponderantly book material. So technically, the instructions say, usually you can tell how it fits, and you should choose the preponderant authorship. But as long as any part of it is in the work that fits the application, the examiners aren't going to be writing. If they have to write about something else, they'll mention it. But if that's all that's wrong, they won't. Yeah. No. The issue will be, does the person who owns the illustration also own the text? And if they both do, you can register them together. If is more likely the case, a different owner owns the illustrations, then yes, they are going to have to be a TX and a VA. I think that's probably going to be like it is today. So those are, separate deposits for each. You're going to have separate for every registration, you're going to have a separate deposit, basically, as it goes through the office, I think. Okay, so those are the 5 classes. There are 5 forms that go along with them, and the reason I used the TX form was because it has more information. It's very important the way that the remitter opens this, like an accordion. Ta-da! And it really says, the instructions say, first, read the instructions, which you hope everybody does. Second, tells you how to open the form. There's a rather sad story behind the forms, the PA form. PA form was folded wrong by the printer. And it's folded so that when you open it, you don't see the instructions. It's folded like, I guess like this somehow. Anyway, when you open it up, it opens up like this. And what everybody was afraid of was people seeing it for the first time aren't going to realize that there's a set of instructions and they're going to start filling out these lines. And this is so different, they really may make some serious mistakes. So we went back to the printer and we said, look, this does not meet the job specifications. It was determined that it substantially complied with the job specifications. Therefore, the printer would not reprint it without cost to the Copyright Office. So then the Copyright Office went to the GPO and said, can we reprint it ourselves? And the decision was made, no, you really can't. It basically substantially complies. Therefore, you cannot waste taxpayers' money in printing them again just because it's folded wrong. So they're all folded wrong. Some of them we try to refold before they go out, but they're in such bulk. There's a million of they printed 1 million PAs and 1 million TXs. So they're going to go out folded wrong. And I think the music section is going to take the brunt of that if people start filling them out wrong. Anyway, it's a whole new format. It's really kind of neat. You'll notice that, like we mentioned back in the Maxi class, that there's no certificate portion. And a new announcement, that ML175 that's at the end of this, explains why we went this route. So in case the public doesn't understand what we did, we mentioned that it avoids correspondence. It means that the certificate is going to be just like the application. And the only detriment to them is they're not going to get their certificate quite as quickly, because a decision has been made that we're not going to mail the certificates until the end of the cataloging process. And that has a plus as far as examining and referrals are concerned. The applicant won't have the certificate in hand when you guys find an error and send it back to examining. When you send it back to examining, nothing will have gone out. And many of you may know that many applicants feel a certificate in hand is better than one that we promise. And we have a very hard time getting certificates back. So in this case, that's probably a plus, but it is going to take a long time. And the instructions to the public say, please bear with us, that's kind of what it says. It says it's going to take a longer period of time. So that's spelled out in that ML175, which is the very last one in the group that you've got. It says there will be some delay. There'll be a lot of delay in the beginning. Okay. The way that the forms are filled out is the instructions. Well, first of all, they don't call them lines anymore. They call them spaces. And the space 1 instructions line up with space 1. Then you go down to space 2 instructions, and they line up with space 2. And space 3 instructions, etc. Same thing on the back. There are 6 lines on the back, and the instructions line up with them. If you're on the back, you'll notice a new animal. It's called a continuation sheet. And this means that if the information that is requested cannot fit on the basic form, you use continuation sheets. And you can use continuation sheets for additional authors, previous titles. What else can you use it for? There's about 4 things that they say you can use it for. One of the things they don't say you use it for is space 5. It says space 1, 4, 6, and 7. And when you use the continuation sheet for those spaces, you have to check off the line and then include it in here. So if there are more titles than there's room for, the applicant would go to the continuation sheet, check off in space C, space 1, and put the alternate titles. So you're going to be looking in different places for different information. We're also saying that all authors should be listed except for collective works. So if there are 10 authors, we want 10 names. Today we say, like, give us 3 and say, and others, or and 7 others. In the new law, where a work is done by more than one person and it's a joint work like a song, we say the last surviving author becomes the measuring life. So you need to know who the authors are. Can you find out who died when? Because the last one to die determines the term. So we want all the authors. And we're telling everybody you can have as many continuation sheets as you want. Just fill them all in. So it's going to be a little bit more work in that area. When a continuation sheet comes in, I forgot to bring it, the mailroom is supposed to tag continuation sheets by putting them in a folder that's bright blue, and it says property of the U.S., of the Copyright Office. And that tells everybody that there's a continuation sheet with it. And they also have to be pulled out separately because when they are mailing these out, the certificates out, they have to be done separately because they have to be put together. All the continuation sheets have to be attached to the basic application form. Remitters are going to have a hard time with this. We've always said, please do not send any separate pieces of paper. Get everything squeezed on there that you possibly can. And if you can't get it, that's it. And now we're saying give us as much as you possibly can and use as many continuation sheets as you need. So they're going to have a little bit of problem with that. So there are continuation sheets. And every form has a continuation sheet on the back of it. And it will be like a PA/CON, an SR/CON, an RE/CON, VA/CON, and they can get them separately. by the way, the forms also come with and without instructions. So big remitters can actually eventually get the forms without instructions and just separate continuation sheets. They don't have to worry about all this stuff and getting it in the typewriter. Now the forms, they really look different, right? If you look at the very top of the Form TX, here it says TX, United States Copyright Office, registration number. The examiner is going to be circling whether the work is published or unpublished. If it's unpublished, it's going to have a U number next to it. So in this case, it's TX, TXU. The PA forms, which are for music and dramatic works and motion pictures, will have the same thing, only it'll be PA, PAU. And they're circled, and then the numbering clerk will put the number in the right series. And we're starting again with a TX1 and a TXU1 starting on January 1st. Then you'll see something called the effective date of registration. And examiners are going to be putting that in. And this is very important because it triggers certain kinds of remedies that a remitter can get when his work is infringed. And we kind of have made a decision. It isn't out yet. This is one of these tentative decisions, but until you see it in writing in a regulation, it's not permanent, that if we get an application that on its face qualifies, in other words, it does have the citizenship of the author or the domicile of the author, and the work is eligible because the person is a United States citizen or because it's published in the United States, and it's substantially identified on the application so that you know the application you have goes with the copy you have, that will be an acceptable application, and we will, not for purposes of registration, but for meeting the effective date of registration. And even though we have to send it back for signature, and even though we may have to write about a lot of other things, the date that we're going to give that application is the date that it originally comes in. And the reason we did this was the date is so important to get the earliest possible date. It looked like we weren't going to write as many times as we should. And it was going to end up in sloppy kinds of applications. So we kind of decided that we're going to give the earlier date as much as we possibly can. So if it does say an author's name, and it does say he's a citizen of the United States, or that it's published in here, and it does have a title, when that application comes in for the first time, that's going to be the date of that application for figuring the effective date. And as long as you have an acceptable copy, and it meets the copy requirements and an acceptable fee, you're going to have the date that all three things are received. And we're going to basically be backdating a lot in this area, but the practices are still being developed. Okay, the examiner's going to put that on, and you're going to pick it up in your catalog entry, the effective date of registration. Now, what they do next is they go to the title of the work, and the TX says, in the VA, have, if this is a periodical, also give volume number and issue date. And we've kind of decided that that's important, and if it's not on the application itself, but it's clearly on the copies, the examiners will be annotating. We had a meeting with Ms. Ringer who said, I don't want annotations, but we're interpreting she doesn't want annotations that cast doubt on the work, not annotations that merely add material that's clear. So we are saying that they will be picking up that material by annotation. If it's not clear, they'll be sending the applications back. The previous or alternative titles, that's purely voluntary on their part. There's a good reason why they should give it, but if they don't, we're not going to worry about it. If it's a contribution to a periodical, they're supposed to fill out the second part of this. Now, the PA form is different in this area, and so is the sound recording form. What they say instead of contribution to a collective work, that kind of a thing, they ask for what type of a work is this? What's the nature of the work? And they want people to say, is it music? Is it dramatic work? What is it? And the issue already has come up is, what if they don't say what it is? Well, it's if the examiner can really tell what it is, and he has no doubt, he will add it. If he can't, he'll send it back and have them describe the work. It was the kind of thing like they decided it was kind of important, and they didn't want to be judging it, and we really did need to know what kind of a work it is. But that's on the PA form and the SR, and it's not on the TX form at all. So that's the first space. I don't think people are going to have too much trouble with this one. They may have problems with space 2. And you're supposed to list all authors, and we've already got criticisms on the way that this line is set up. Remember, under the new law, it's important in determining term to determine whether or not the work is made for hire. Because if it's made for hire, the term is 75 years from publication, 100 years from creation, whichever is shorter. So each space starts out saying, was this author's contribution made for hire? And what you're supposed to give in this space is the name of the employer. And everybody tells us that the way it's worded, it looks like you should give the name of the employee. And do you all agree? Every training session we've done, they've gone right up the wall in the industry. So we say, well, don't, just remember one thing. You give the employer, and if it's made for hire, just say yes and don't worry about the instructions. I guess we're going to have to reword them when we do it. I guess you didn't have to say, I guess the problem is this author's, because they're an artificial author, and all you really had to say was this contribution made for hire? I guess, I don't know. They fought about this for a long time, but everybody thinks it's confusing. It's supposed to have only the name of the employer or John Doe Company, employer for hire of William Allen Warren.
Write it out.
Yeah, I mean, it has.
In other words, if they give the person who's obviously the actual author and say yes,
We have to have the name of the employer. And they've decided that where an individual is given and it says, yes, it's made for hire, it's unlikely that too many individuals are employers, and we're going to write in all those instances. And the only time we wouldn't write where they didn't answer that question, they're supposed to say yes or no. A lot of people aren't going to answer it, and if they don't answer it and an individual's name is there, we'll probably assume that it's not made for hire even though they don't say no. I don't know. This is all tentative. We have forms. This is the good news. We do have forms. The bad news is we don't have any practices. None. We are trying to develop some. And hopefully we'll have them by the third week in January. But right now there are no established practices. Why? Because our general counsel, my former boss, tells me that we cannot have practices until he drafts a registration regulation. And he hasn't drafted a registration regulation, and it is on his list 2 down. And so we may have one in the next 2 weeks. But until we have one, we can't have practices because he's going to set out some basic practices that we have to work with. So that's why we're kind of fudging. We're waiting for that regulation. And I'll talk about that a little bit later. Okay, if the work's made for hire, they give the employer, and they have a choice of saying employer for hire of and giving the individual's name. But in training sessions, we've been discouraging that because they usually mess it up which way. We say just give the employer's name. If it's a work made for hire, you don't give a birth date or the fact that a person is dead. And in fact, if they gave that, that would be confusing. If they check it's made for hire and they give this, that casts doubt on what kind of a work it is. If it's an individual, they're supposed to give the facts about their birth, though it's optional because it's an additional identifier. If an author is dead, they should, in fact, give the date of death. Someone already has raised, what if they say, don't know whether they're dead or not? What do you do? And we're hassling now with, do you go back and say, we know we're going to go back and say, try to find out whether they're alive and dead. And if they are dead, try to find out when it happened. But if you can't find out, we're hassling over, do you just say, don't know, or you make a good guess and don't qualify it? And I think probably you say, don't know, because that does put the public on notice of saying the facts really aren't clear. And if you do say, guess at a date that he died, that's really unclear because you're going to go life plus 50, and that really does create a false record. So I think probably don't know is better, but that's something we haven't come up with yet as a practice. So you may be seeing don't know. What do you do with that as a cataloger? I don't know. Or unknown. I don't know. You may be seeing some of those. New law says you give nationality or domicile. You don't have to give both. We've already picked up an error in the instructions which say that you're supposed to give both. And that has to do with where the author's identity is not revealed. In space 2, it says you must give nationality and domicile. That's a mistake. You only have to give one or the other. Somebody has raised a question in the examining division for works published before January 1, 1978. It's important to know a person's domicile. And if that is a qualified, will we write about it? And I think the answer is basically yes. But for works created after January 1 or published after January 1, you only need one or the other. Then it says, was this work anonymous or pseudonymous? And the instructions say that means the copy. Does the copy have a pseudonym on it, or does the copy not have any name or just a non on it? And if the copy has it, you check yes. And then what you do with that depends, because it says if you check yes, go see the instructions. And the instructions say you don't have to give the name. And if you don't, it's this funny term of 175-year dichotomy. But if you do give the legal name and identify them, then it will be the life of that identified author plus 50 years. So when they check yes, that doesn't mean you're going to get a suit here. or no name at all, the instructions tell them they have a choice. And they can give the legal name of the author. And they can give the legal name followed by the sued. But yes does, all yes means is, if you're filling out this form and say yes, go decide whether or not you want to give us your true name, and we'll tell you why you might want to do it either way. If they check yes, it's anonymous, and they decide they don't want to give a name, that's perfectly okay. The only thing they have to do is give either the citizenship or the domicile. They don't have to give both. So you may see some strange things. No name at all, and just yes, U.S. citizen. Or just no name at all and domiciled in France. So you're going to see some funny things, right? But that's what the law says. You don't have to do it. New feature of all of the forms. Only the Form E, the music form, had this before, but now every single form says, describe each author's contribution to the work. So, and they have some examples. If there's only one author, they can say all or book, but it does give some idea of what they should do. But every single form has nature of authorship statement for each author. And I assume you're going to be picking that up, right? Yeah, okay. So they go through that, each one, and examiners have already made a decision. If they try to interline material or put two on one line, we're going to send it back. Only one author per space. That makes it a lot easier. Any questions on line 3? If there's more than 3, they're going to be using continuation sheets. And the way you find out that there's more, there's a thing at the bottom that says page 1 of how many pages. And if they fill it out, fine, but if they don't, a technician or an examiner will be filling out how many pages there are to this application form. So you'll know to keep going. If it says page 1 of 4 and you've only got 1 before you, there's 3 floating somewhere. Okay. Space 3 has 2 things in it. One is called the year of creation, and that's when the pen was set down. And the instructions basically say that it's fixed at different times. If you write a novel and you start it in January of 78, whatever you finished in 78 is fixed, and that's when it's created. If you do let's say you have a 13-chapter book, and you do one chapter January of 78, the second one February of 78, and you decide to register those 2 chapters, it's fixed 78. If you decide to wait till you finished all 13, so you did one in January of 78, one in February of 78, all the way through, and the last one in January of 79, and you register in June of 79, you put 79. It's the last, whatever you're sending us in, whatever in that copy, when did you finally complete what's there? And people say, a lot of people are probably going to say, January 78 through January of 79. Is that acceptable? I think we're coming up with yes. Whether you pick up only the last date as catalogers is something else. But we probably are going to allow them to put a span of time, 1960 through 1975, because it's not worth writing about, and the instructions say it's the last year. They may want to show that it was in existence a long time previously in case somebody later comes in and says, hey, I only took a little bit of this and it was created in 75 and I got it in 62. They may want to show that there was something in existence in 60. So we're not going to force them just to give the last date if they give earlier ones. If they say don't know, which is a possibility, we're going to write. And again, if they can't find out, we're probably going to let them say don't know or unknown rather than make them make up a date, because to make up a date may be misleading. Where this will happen, let's say you're a music publisher and you frequently get a lot of tunes. Say you got some in 60, some in 62, some in 64, and you never bothered to register them, and now you're going to do it. And the author, the composer, has flown the coop. You really had no idea when he wrote it, but you're registering it in 78. It can come up fairly frequently. So that's something to watch out for. But you may see some strange dates, and what I guess you do is just pick up the last date. Okay, so ask for the date of and nation of first publication and the name of the country. They do need the name because that can qualify the work for protection. There's a strange definition of publication in the new law. It says that when it's made available to the public, whether it's by rental, transfer of ownership, lease, or whatever. And it also says offering the work to a group of people for purposes of public performance or for public display as a performance. And the music industry is already up in arms. And they say, what if I write a song and I offer it to an orchestra, a group, this orchestra, to perform it to see whether or not I like it. And they perform it. And then I decide it's terrible and I tear it up. Is it published? Technically it is. And they say that can't be, and I don't know whether it is or isn't. It does look like there's a problem with the definition of publication. But anyway, Rental definitely does publish the work. And we've asked for 2 copies of the Rental edition, and the music publishers already have filed enormous complaints saying that that's too expensive and they just cannot comply. Okay, the 4th line is the problem line. 4th line says, give the name and address of the copyright claimant. And one problem is, who is the copyright claimant? And we don't know who the copyright claimant is. Our regulation is going to define the copyright claimant. And it looks like it's coming out like this, but until you see it in writing, you can't count on it. The author, since he is the original, always can be a copyright claimant. Or somebody who takes all rights from the copyright owner. I write a song, I hereby give to Melita all my rights in the song. She's then an owner of copyright, and she can be a copyright claimant. And the 3rd thing we seem to be coming out saying is, if by contract you get the right to claim copyright in your name and put your name in the notice, you can also be there. But other than that, you can't be. You own an exclusive right, the right to publicly perform the dramatic work, which is the most important right, probably. You are not an owner of copyright, although the statute says you are a copyright owner. There is a difference. And your name cannot go in space 4. Okay. Now, how it works is, what people are already worried about, you're supposed to have 1 name per space or divide them by an and you can use a continuation sheet. But there's got all of this big space, and everybody now is criticizing the fact that people are going to get messed up with this space without further directions. We'll have to see. The problem line probably is the second part of it, and it says transfer. And it says, if anybody named at space 4 is not also named at space 2, please explain how that person or party got the right to claim copyright in the work. And the problem is, what do you put? Well, it seems you can say assignment of copyright. It seems you can say transfer of copyright ownership from author or something like that. Or you can say bequest or will. Other than that, I don't know of any acceptable statements. And I assume that we will have acceptable statements and unacceptable statements in our in our registration regulation. I just don't know. Some obviously unacceptable statements. Found it, stole it, gift, that kind of thing will definitely not be acceptable. Contract may or may not. I can give you a contract to perform the work. That doesn't mean that you have a right to claim copyright in it. So I don't know. We're going to have to bear down on that line, and I think there's probably going to be a lot of correspondence on that line, which we hope will be cleared up by the time it gets to the cataloging division. Anyone have any questions on the first page? Okay, go to the back. Let's start at the very top and work through. There's boxes that are way above this deep line, and it says examined by, and that will be the initials of the examiner. Checked by. And this is not necessarily a reviser. In the examining division, it means a technician, and we tell the examiners that checkers are less than examiners. They're not reviewing examiners' work. But the check by is the technician. If there's correspondence, there'll be a check. If deposit account funds have been used, there'll be a check. And the service division will be putting in the dates that are in the second column over there. Okay. What the applicant will be filling is below this dark space. And here I think there's an improvement. The old form had a line 5 that had instructions that were most misleading, and nobody understood them. And it said something about, if this work was previously registered or previously published, please complete it. But nobody understood whether or not it was only if they previously registered it, only if they previously published it, or anybody. And I would bet 50% of the correspondence, especially in music, is about line 5. And I think this is really going to help, because space 5 only asks one question. Was this work previously registered? It doesn't say, was it previously published? Only, was it previously registered? Registration certificate in hand. And you answer yes or no. If you answer yes, you must have a reason why you're seeking a second registration, and they must check off one of the 3 boxes. And the first one is, this is the first published edition of an unpublished work. This is an exception to the rule. Basically, 1 registration per work, and no more. There's an exception. In fact, there's 2 exceptions. One is in the statute. It says, if you registered an unpublished form and you are publishing the exact same thing, you still can register it again. And that was put in because the publishers are going to have to deposit copies anyway here. Since they have to deposit copies and they probably want proof of it, it's going to cost them $2. For another $8, they can have the facts of publication put on the record. So that's an exception. The second exception to only having one basic registration per work is this is the first application submitted by the author as claimant. And a decision basically has been made, though it's not out yet, that the author can always make a basic registration. So even though a book publisher makes a registration in the name of the book publisher, the author can always come back in and say, I want a registration in my name. What we haven't worked out is if the author decides to do it, what will he deposit and how does he fill out this form? And we really don't know. And I think that in trying to work out how this author can make a second registration thing, we didn't think about it until after the forms were printed. If they could go back and change their mind today, they would. However, there are a million forms with this on it, and so we are kind of stuck with it. And we're going to let them do it, but we really don't know the mechanics of how it will work. And the reason for this was, I guess, they were afraid that they thought that authors should have some rights to put their registration on the record, but they never thought through how it would work. Let me give you an example. Let's say that I write a book and I give it to Doubleday, and Doubleday substantially edits it and publishes it. And it publishes it in the name of Doubleday. There's really two copyrights in that. There's really mine for my authorship, plus what Doubleday did as an employer for hire of the editor. Doubleday makes a registration and they publish the book. I decide after they do that that I really want my own certificate in my name. What do I use for deposit copy? The stuff with their authorship in it? Do I put them down as co-authors of mine? I don't know. I really don't know how that's going to work. And nobody else does either. So if anybody gets any questions about how this works, we don't know. All we know is that we are going to let the author make a second registration after the publisher, and when we have some instructions, we'll be putting out a circular or something on how this is done. But in the meantime, we just don't know how it's going to work. Okay, the third thing is this is a changed version, and that's really pretty much what the normal reason for doing it is. I registered the melody, and now I have a new arrangement. I registered the book, and now the book is out with illustrations. So it will check, this is a changed version. And if it's a changed version, then you're going to have to describe the, certain material in line 6. It does say, if you give yes, please give the registration number and the year of registration. And the instructions say you only have to give the last one. You don't have to string out every registration number that you can think of. Basically give the last. So that should be easier. It only says, do you have a registration? If yes, check yes. Tell us why you want a second one. Give us the year the registration was made and the previous registration number. If they leave it blank, where? Jim, I have ruined it. I'll put it back on. Okay. If they leave the registration number blank or the year of registration blank, we're not going to write for it. That pretty much has been decided. Okay, space 6 should be also easier than the old line 5. It basically says if you have any pre-existing material, pre-existing because it was previously published or previously in existence, that kind of thing, please identify it. Example would be a hymnal, and it's got 100 songs, and 75 of them are public domain hymns. So you write down 75 old songs. There was a question about this because the House report is very specific, and it says that you're going to list the pages on which these old hymns are on or give titles. And I finally found out how that ever got in the House report, and it turns out that there was a congressman from, I think, Chicago, who was very upset at hymnal publishers, and he never knew what was in the public domain or what wasn't. So he wanted a requirement that all the new works have asterisks on them, key to the notice, so you could, and there would be a single asterisk for new material and a double asterisk for all public domain material. And publishers went up in arms when they heard about that, and a compromise, in other words, to shut him up, so he wouldn't fight the bill. They put this language in the House report. The Register wrote it. She never intended to follow through with it. And all you really have to do is, in general terms, identify the pre-existing material. You don't have to give titles in. You don't have to give specific pages. So that's the end of the House report suggestion that it has to be very definite. It says if it's compilation, all you really have to do is identify the stuff that you've compiled. If it's a compilation of works by William Shakespeare, you say works of William Shakespeare. Then the new matter is compilation, what you've added. If it's a derivative work, you spell out what the pre-existing work was. Melody, words to the Lord's Prayer. And then you add what you have done to this work. I think, everybody think that that looks easier than the other one? I think it probably is. When you force people to tell what's old, somehow they sometimes can think what's new. And we've also decided that they can combine statements. If they don't fill out pre-existing material and they say material added, all new but, you can figure out what it is. And all new but arrangement, well, that won't work. All new but words. You can figure out what the old and the new is, and we're not going to write in those cases. Forms 5 and 6 spaces are the same on all of the forms. TX is the only one that has the manufacturing and locations, and that's because of the manufacturing requirements. There's no affidavit. We're telling everybody to fill out space 7, even though it doesn't necessarily apply. We haven't decided whether if it's blank, we'll write about it. The 8th space only appears on the TX form, and that's the reproduction for the blind and physically handicapped, so they can make talking books and Braille copies. People on the outside have got very upset about this line. They think the Library of Congress being part of the library and the Division of the Blind and Physically Handicapped being part of the library, that Copyright Office employees are going to check these off, even though they leave them blank. And they want to put great big no's in there. And they keep saying, can I put a great big no? And the answer is, if you want to put a great big no, put a great big no. I don't know. Okay, space 9 is a deposit account space, and there are no numbers yet, but accounting is getting ready to write everybody and say this is your number. And then there is a space for correspondence, where we should write to somebody in case there is an error, which will be about 99% of the cases that come in after January 1. That always happens. Okay, 10 is really different. 10 says, I am certifying that the facts are true, and we have a neat statement about a falsely giving wrong information, the fine that you will be subject to. But you check off who is signing this and who do they represent. So if you're the author, you check author. If you're the other copyright claimant, the person who got all of the rights from the author or by contract has the right to claim in his or her name, you check that. Or if you're an authorized agent, you check that, and then you fill in authorized agent of who? Author, copyright claimant, or exclusive licensee. Exclusive licensee can sign this and file this. He just can't file it in his own name. He's going to, he'd have to file in the name of the author. If I wrote a play and I gave Warren all rights in my play, all public performance rights in my play, he's an owner of an exclusive right. And if I don't register my claim, to protect himself, he can register it too, but he'll have to register giving my name in the claimant line. And then it has a handwritten signature and a typed or printed name. Obviously, if you can read the handwritten signature, they're not going to send it back and say, please type the name that represents. If you can't read it, they are going to send it back. And this is going to be important, because when we get to the corrective entries, whether or not they're tied to the new, the old registration will determine on who signed this form on whose behalf. And only certain ones are going to be tied together. And they're really going to have to know who signed this form and on whose behalf. So this line's going to take on a lot of importance. There's a date. It's optional, really, if they don't give it. They just stuck it in saying, what day did you actually fill out this information? Because sometimes they fill it out a long time before they ever send it to us. And it will give an idea of whether the information is current. But if they leave it out, that's it. And the last one is where you mail a certificate. Might mention that there's a Privacy Act statement on all of our forms, and this one says, as you all know, Copyright Office on January 1 is subject to the Privacy Act and Freedom of Information Act. Privacy Act says, where you are eliciting information about individuals, you must tell them under what authority you're asking for that information, whether it's mandatory or voluntary, and what uses it will be put to that information. So we tell them under what authority we're getting it, which is 409 and 410 of the new law, that furnishing the information is voluntary, but if they don't furnish it, we may have to either delay registration or not register it at all. That's the kind of voluntary it is. And then it goes on and says, yes, the uses we will put to this, public inspection and copying, and the preparation of indices, catalogs, and search reports. And so that's a Privacy Act statement. So those are the new forms. We haven't tried them out on anybody. We haven't found out whether, we're going to try them out on you, whether or not it's easy to fill them out or not. I think when people get used to them, they won't be bad. Let me just mention one other thing. A policy decision has been made that if you are claiming in sounds and the underlying material, in other words, you've got an audio cassette, and on it you have a lecture, and they're claiming in the lecture and also the sounds, that the only form you can use is an SR. So if there's a claim in both the sounds and the underlying work, if it's an electronic musical composition and the guy performing it is registering his sounds and also his music, you can only use a form SR. That's a purely arbitrary decision. And the only reason they did that was they only wanted to put the instructions on one form, they only had space on one particular form, and they chose the SR in order to do that. And the SR form has those instructions, and the PA and TX sort of do too. They, it says somewhere, it says something about if you're claiming in both, you must file only an SR. In order to do an SR and claim both, the owner has to be the same for both. And I think that that means that hardly anybody can do that. And where it's probably going to happen is in the literary area, where it turns up on cassettes. Not very much in the musical area, because music publishers usually own the music, and recording companies usually own the sounds. But in the audiovisual kit area, or in something like doctors' lectures, the sounds and the underlying material are frequently owned by the same party, and they'll be using an SR form. There's a problem when you have that we haven't resolved, and we're not going. I don't know how we're going to work it, but let's say that you write a lecture, and then later you delivered it in a microphone, and you have background music maybe played in, and you decide you're going to copyright your lecture and the sound. And the question is, when was it created? You really have two works. And I think we're just coming out with the later date, which will always be the date of the sound recording, because that will always come last, is the year that you're given the SR form. We're not going to spell out, give the date in which the lecture was created and give the date in which the sounds were created. We're only going to ask for one. Does anyone have any other questions about the forms? Yeah. That's kind of funny. You have a right to, if somebody else has published their music in the form of a sound recording or authorized somebody to bring out records in the United States, anybody else may make similar use, which means that anybody else can use it in background music, as long as they pay the owner of the music for every single cassette that they happen to have sold. So yes, they can, but they're going to have to pay royalties on the music. But they can claim copyright in their interpretation of that music. And they can claim in the lecture that they did, and they can claim in the sound engineering. Anyone else have any questions? In that is, definite decision has been made, and I think it's in Policy Decision 6 or something that was issued, that publication of the sound recording publishes all the material on it, including the music, and that's very different than what we had under the old law. And we talked about this in the maxi class, and I said, I think that's the way it's going to go, and that's the way it's gone. It does publish the underlying musical or literary material. We're also going to be accepting phono records for deposit copies of unpublished works and, in some cases, published works. And I'll do that when I go through the deposit regulation. Bruce, do you have a question?
Yes. Is there any restriction on putting together unpublished collections, such as Form TX, all the poems and plays that they've saved up, or, well, not plays,
No.
but poems and articles and so forth?
Probably not. I don't know how they're going to do it after January 1. Music has always allowed, under certain conditions, collections to be registered, and it was supposed to be, had to have 2 or more, it had to have a single identifying title. You had to either have continuity of authorship, the same author contributing at least some part to each one of them, or it represented the work of a single author in its compilation or editing, that kind of thing. They've decided that that certainly is going to continue, and they're going to put it in the registration regulation. And then they decided, why should that apply only to music? It shouldn't. It should apply to all works across the board. So it will be there, and I think it's going to go the way the music one goes, but until they draft it, I don't know. Then the issue is, can you do it just on a plain TX, or are you going to have to do it with something called a TX with an adjunct application called the GRRW, we've got other forms. Have you heard about the GRCP? GRCP, Group Registration, GR. CP, Contributions to Periodicals. And it's an adjunct application. You don't use it just by yourself. You use it in conjunction with like a TX or a VA. There's one over there. And all it does is have extra spaces to give the periodical title, the volume number. And so you will be getting a TX with a GRCP. Now they're also going to have a GRRW, which is Group Registration for Related Works. And I'm not sure that that unpublished collection is just going to be regular TX, or are they going to set it up that it's a group of related works that are registered together? I don't know. Group of related works is supposed to be, a newspaper can register their 3 editions on one application with one fee. They were talking about that certain designs, if you're an artist and you design cardinals in all kinds of positions, you can register those cardinal designs on one form. It may be that the GRRW only relates to published works that are related, and that you use the regular form for the group registrations of unpublished. But until we get a registration regulation, your guess is as good as mine. You may be getting nervous that this is now, what is it, December 8th? And all of these things are undecided. However, we have more time than you think. We figure even if the stuff starts coming in January, by the time it gets up to the examining division, it will be the 3rd week in January. And so we're aiming for maybe the 2nd week in January to have the practices set. I'm serious. They'll be ready. They're just not there yet. Anyone else have any questions? I'm too energetic. I never should have had one of these. Anybody else have any questions on the forms? Yeah.
To do their audiovisual kits on Form A, also making a registration if there's a cassette in Class A. And at one point you said they would use PA, Class PA?
Mm-hmm.
Okay. Even if there happens to be a great big book with it, which is
right.
Also published. Okay.
The definition, if you've got any kind of a thing that can, which you perceive a work, or you use any kind of equipment to perform it or whatever, that's defined as an audiovisual work. And we're saying anything that's in a kit that has one of those things in it, the whole kit can be called an audiovisual work. And you can register the whole thing in Class PA. It's got to have a film strip or something in it. It would have to have a motion picture. It would have to have something that you use equipment in which to see, and it can't just be a set of slides. May or may not be an audiovisual work, and it depends on whether there's continuity, continuous action, they're in a set order, that kind of thing.
This one this morning was a company which regularly supplies material to medical schools, and they have a set of slides which are geared with inaudible tones.
Mm-hmm.
With a cassette.
Right.
Formerly, the way they did it was they did a C registration and N registration, and sometimes a J registration separate for the slides. How do they do it?
PA. One form for the whole thing.
That's all.
That's all. Anyone else? Victor.
Suppose we don't have any material that has to be projected or any films. Suppose we just have a book
And a cassette.
and a cassette and maybe some
Pictures
pictures.
that you see that you're right. That decision hasn't been made on what you do. It will be in the registration regulation. But it looks like, well, they started out saying that you do the whole thing in SR. If there's you do the booklet, you're only going to have to make one registration per unit of publication. And if you had a sound, they was kind of saying SR. But the last time I talked to Ms. Ringer, she was talking about, well, she didn't see why they couldn't do TX. And she didn't see why they couldn't do VA for the whole thing. And until that decision is made, this is one of these things that people vacillate on from week to week. And until you see it in the registration regulation, you can't count on anything. So if you get that kind of a question, I think it's clear that that whole group can be registered in Class SR. What's not clear is if they can also pick, in your fact situation, TX or VA. And the reason why it's clear it's SR, the problem seems to be that they've made a decision and they put it in the form. If you are claiming in the sounds as well as the underlying work, it's SR. And it's kind of is like, can you have a sound recording in any class other than SR? And that hasn't been decided. So it may be that the whole thing's SR. If you have to tell them anything now, you can tell them that it really hasn't been decided, but they're safe in filing SR. Whether they can do any other ones hasn't been decided. And if that doesn't make them very happy, tell them you're not happy either, that you can't give them more accurate information. But an SR is a safe form.
Every registration, or every application that comes in, there has to be deposit copies. Does that mean if I want to register
They're
my...
going to separate classes, I guess.
Right, if I want to register my audiovisual package on a TX, on an SR, and a PA, am I going to have to submit 6 copies?
And it's all you. No, you still can only do the 2.
Okay.
If there's different owners, let's say somebody owns the illustrations and somebody owns the book, normally they won't, whether they have to have 2 for each one, I don't know. They may make some exceptions to that. In other words, I think they probably come out with exceptions because they don't want the library to have more than they actually have to have. They don't want to put a burden on the public. But they haven't drawn that practice up yet either. But the old law, which was stricter, you could send just 2 copies and group them all together, and I can't believe for any reason why we wouldn't, unless they came in separately. If they all came in together, if you had a VA application for a set of slides and you had a TX for the book, and they had an SR for the sounds, besides being, and they all have the same owner basically, and they all come in together, I think you only need 2 kits. But they're kind of, you know, they're going to have to pay $30, so I think they're probably only going to do 1 because of the fee structure. Anyone else have any questions on the forms? Yeah,
Will you be accepting a TX form for a game?
probably. If it's got any text on it at all, they'll take a TX. If there's no text, then the only reason you'd be registering it would be the artwork. And I guess if no text, it's hard to believe a game without text on how you play it. So I assume that TX is going to be okay. Yeah. Anyone else? Yeah.
This one might not even be relevant. But on the double registration thing, a publisher claims, registers the claim copyright. And the author wants to also, he presents his manuscript, but it'd be rejected as not being the best edition.
No, because he's going to be giving it to us. That's one of the hard questions. If the publisher has registered it on the basis of the published copy, and the author now comes in and says, hey, I want to register my claim and I'm going to give you my unpublished manuscript, it seems that that should be what we're taking because that's what his authorship is. But how can you register an unpublished work after the work's already been published? And nobody's figured that out yet. Yeah, second one.
The distinction of foreign works, is the only distinction be the place of publication.
Yeah, there's no foreign forms, and there won't be any foreign designator. They're all going to be numbered the same way. And it really doesn't matter. The only thing that matters under this, except for books, is the work eligible? And you're going to show eligibility the fact that it's published in a country we have copyright relations with, or something like that. The only time it matters whether it's, and it's not even published abroad, has to do with certain books in the English language that are supposed to be manufactured in this country. And that's the only time it matters at all, whether it's foreign or non-foreign. Or with the deposit copies. If it's foreign in origin, they only have to send 1 copy as published. If it's not foreign, then they send 2 complete copies of the best edition for our purposes. And that's the only, difference in whether it's foreign or not. Anyone else? They're all going to pay fees. Yeah, Victor.
I had a question the other day from somebody who was reading TX, and they saw that it asks for, has this, in the title line it says, has it given, let me see, if this work was published as a contribution to a periodical or a serial or collection, give information about it. Okay, this fella had part of this book published in a periodical, and he wanted to know, even though he was going to be registering the book, if he had a list there that this was published. I said I didn't think so, but that would be a new matters thing.
It's aimed at the fact that they're giving, it's aimed at basically serials and periodicals. And what you're doing is you're giving an individual title, and they do want to know what's the collective title and what volume it is. And it's not aimed at that fact situation. his fact situation, if it was previously published as part of a periodical, he's going to have to fill out line 6. But that's the only significance it seems to have to me.
I think what Putin was, it says serial or collection, and it doesn't.
That's because we're trying to get so many things on the same form. We've got periodicals and books, and books many times are collected works like anthologies, and they had to adapt it for everything to be on this form. And as Mildred Henniger pointed out, the instructions, though they don't count out unpublished collections, they really aren't addressed to them either. The instructions really don't quite go right to the heart of an unpublished collection. And everybody said, yes, when we drafted this, we were only considering published works. We didn't even think about the unpublished works. So, obviously, these forms are going to be changed if they don't work. And we've already picked up errors in several cases in different parts of the form. Okay, let me tell you something about some other applications. They have come up with a JB, which is the jukebox application. We haven't come out with it yet. There's an IS application for import statements. There's these GR applications. And then there's a CA, which every one of you should have. And a CA is the way that you correct a registration or you take care of changes that have been made from the time that the work was registered. And this should make it a lot easier. And if you look at this, it says you use this only to correct facts that are in the basic registration. If there's a problem with the copy, the wrong name is on the copy, or the copy that you sent us was wrong, you don't use this for it. And what it does is it comes in just the application at a $10 fee. It costs $10 to do this. And this is the way you take care of change of titles. The free cross-reference cards are going out on January 1. They can't do it. If they want to put a new title or they want to put the new name in the records, this is the way to do it. It costs $10. Okay, if you look at this, not so much the instructions, but the interior part, you'll notice right away that at the top it says registration number, and then it strings along all the classes. It's only a Form CA, but when it gets numbered, it's going to get numbered in a basic registration class. And the examiner is going to be circling what class to register in I talk backwards. And you can correct old registration, so it can be a Class E registration that you're now going to correct with a CA. And you're just going to do a conversion. It will be registered in Class PA. The CA will. So this is really a second registration. It's called a supplementary registration. It is numbered in the same class as the basic registration or an equivalent class. If it's an old class, A would be TX. There will be a certificate, and the reports of the register say that that certificate also is entitled to prima facie evidence of the facts it states. Now, how this works, and the only problem with it, first of all, you have to have complete information about the old registration. Why? If you make it easier. The thing, as I was saying, is that you really do have to have complete facts of the previous registration, and that may or may not require having a search done, again at a $10 fee. Because space A says, give us the title of the work, the registration number of the previous registration, the year that the registration was made, the names of the authors of records, and the names of the copyright claimants. And if you don't have that information, they really are going to be writing. The examination on this is going to be something like renewal examination, where you really do get the old application, and the examiners really are going to be comparing this against the old. And if the space A information doesn't quite connect, they're going to be writing. Now, what you're supposed to do is decide whether you're correcting or amplifying. And correcting is supposed to be whatever was in the basic registration was wrong. It's there and it's wrong. It said it was published on December 1st, 1960, and it really was published on December 20th, 1960, that kind of a thing. If you think it's wrong because you left something out, it's not wrong according to our instructions. Our instructions are that what's there is wrong and you're correcting it. If you left something out, the application doesn't have wrong facts, it's just incomplete, in which case if you're trying to add to it, you amplify and you go to space C. In explaining this to the public, they got really uptight about this. They thought what we thought was an amplification was a correction. So a decision has been made, and it goes along with the decisions you've made, that if they mess up the spaces and put what belongs in C and B or vice versa, we're not going to write, as long as it's clear what they're trying to do. But what they're supposed to do is if they're correcting, they're supposed to tell us what line they're correcting. If it's an authorship thing, it would be basically, under the old application, it would be line 3. Under the new one, it would be space 2. That's interesting they said line because the other one says space. Okay. And then it says line heading. I guess it could be authorship, line 2, space 2, authors for the new forms. And then you give the incorrect information, which people sometimes don't like to give. Tell us again what's wrong, and then tell us what's right. So you give the wrong information and the right information. I said the author was John Doe. Correct information, author is Mary Smith. And then it says explanation of correction. They can explain why they gave what they did, but they don't have to. If it's amplified information, in other words, there's been a change in title, change in name. They said the work was all new, and there's a new matter statement that they need to give now because it really wasn't. Then they go to space C, and all they do is identify the line that this affects, and then give us what it should be. So that's how it works. And it will cover all kinds of corrections and all kinds of amplifications. When you don't use it to make certain corrections and renewals, and you don't use it to show transfers of ownership. If it's registered in the name of the author and now the publisher has all rights in it and he wants to show he has rights, you don't use this. This is not for transfer of ownership. It's only to correct or amplify transfers of ownership or showed by filing documents, and they file the actual document of transfer, so they don't use it for this. Anything else about these? They pretty much go like the other ones do. There's continuation sheet on the back, and you check, I'm continuing space B or C, and then they have the same kind of a certification line. Might mention there was a lot of fighting about what the hand was going to look like. The register thought the hand they had was too masculine. Other people thought that the hands they had were too feminine, and we've ended up with this nuded-looking hand. Okay. So this is the correction form. We're going to work through some of these and how it could work in a few minutes. Let me just quickly go through the deposit requirements. We have a proposed deposit regulation that is out. It's pre-printed as ML 174. It's a very long, comprehensive proposed regulation. Don't necessarily study it yet because it's not final, and we are getting comments on it. And it has proposed regulations for the library in which they exempt out a whole bunch of works. The library does not want telephone directories. The library does not want three-dimensional items. The library does not want labels or advertising matter. The library wants globes, but it really only wants one with a stand. The library wants motion pictures, but it really only wants one. It doesn't want two. And it has in here something called the library's best edition for purposes of copyright deposit that are in here, which they have things like they prefer library binding versus trade binding. They prefer spiral versus whatever. Anyway, it gets very, very detailed, and it's all in here. And they have examples of what is complete. Complete is everything in the unit of publication, even though it's not copyrightable. In other words, they don't want globes without stands, and the complete copy is the stand too. That kind of thing is all in this proposed regulation. What's unusual about this regulation is it has a special relief provision. And what is the compliance section is going to be monitoring this. So if what we ask for happens to be what they feel too expensive or unreasonable, they can go in for special relief. And they go basically to the compliance section who decides whether or not the special relief can be granted. And the way they do it is they tell why what we're asking for is unreasonable. They'd come up with an alternative, and then the negotiations would begin. It's kind of like a bargaining kind of thing. There's also a special provision for secure tests. Tests like the law school admission test, the medical school admission test, the graduate record test. People don't want those deposited here for very good reason. They deposited them once, and a very smart guy got an idea that he was going to have a school on how to pass this test. And what he did was he got a whole group of people to go in, they look at it, you can inspect it, but you can't copy it. So each person would go in and memorize 2 questions. They'd go out and meet the guy. And that was the last time they ever deposited a test here. So there's a special provision for secure test. And what it says is, in the secure test area, you will give us a copy, and we will let you take it back as long as you give us a sufficient description to identify what the work is. We also offer the opportunity to have it examined and cataloged under secure conditions, namely in a room with an agent of the copyright owner present. And that is available not only to the secure testing industry, because that would be giving favoritism to one industry, but to anyone else who has similar needs. And what we're waiting to see is who comes forward to say that they have similar needs. It may get out of hand. I just don't know. Okay, with respect to deposit, for our purposes, there's some definite steps that have been made. For example, we are not accepting any three-dimensional items. No more Uncle Sam banks, bird baths, elephants, whatever. We will only be accepting photographs of three-dimensional items. It's no longer optional. And we did set up what we have today on photographs. We would like them no less than 5 by 7, no greater than 9 by 12, and we actually prefer 8 by 10. That kind of thing is... You laugh. It's in here. It's in here. And we will take other items up to 96 inches, but we won't take anything beyond 96 inches. What we're basically saying is, if it's unpublished, we want one complete copy of the work. And we will accept phonorecords if it exists in phonorecord form only. We will accept a copy or a phonorecord if it exists in both, in which case the remitter decides which best represents the work. If it's published, the issue is basically 2 copies of the best edition, and it's up to the time that you're registering the work. And how it works, if it exists in phonorecords and copies, is we want the copies. The library wants visually notated copies. If it exists only in phonorecords, they send us the phonorecords. If it's a foreign work, we want 1 copy not of the best edition, but as first published. If it's a contribution to a collective work, we want 1 copy of the collective work. And for registration, there are also special relief provisions in here where you can go in and negotiate and bargain. People who are upset about this, music, rental libraries, opera scores that they only have maybe, 3, 4 copies. They're very big, bulky, and very expensive to produce. Those works are published. We can get them, and they don't want to send them to us. They're talking about sending us microfilm or some kind of a microform copy. They don't want to have to send that big, expensive copy. Who else are we getting flack from? We're getting flack from a piano roll company who says that since we can't examine these, we don't have play a piano here, we shouldn't ask for 2 copies. And since the Library of Congress really doesn't have player pianos in any big number, that they really don't need any more than 1, and so they've already come forward. Eventually we will have a final regulation. But it should mean, especially in the arts area, that you're not going to be dealing with big, bulky stuff. Examiners say that's going to be harder, because you're not going to be able to see it, and you're going to have to more carefully examine the photographs. I don't know whether that's true or not. So we do have a proposed deposit regulation, and we will have a final one shortly. Does anyone have any questions on the copies? Yeah. David. Corrective registration, no copies.
Even if it involves a year date or something.
Yeah. If it can't do a corrective registration to correct anything on a deposit copy. The only time you can ever do a corrective registration is to correct something that's on the application form for the original registration. Anyone have any questions? If not, let's just take, go through maybe 1 or 2 of these to see how it would look. I'll let you pull through the first one and the 4th one on your own later. And we'll just do 2 and 3. Oh, yeah.
Well, I've had a couple of questions from newspapers who send us a month's worth of applications at a time and then send us the papers every day.
They got a problem.
Okay. Even with special instructions.
Yeah. They've pretty much decided that the applications have to come in with the copies, or they have to have clear-cut instructions. Clear-cut instructions mean a letter or something, not instructions on the box. They may be all right, but the way it works is if there's clear-cut instructions, we wait 7 days to get the applications in fee. If we don't get them in 7 days, then we write for them. And we only hold the material for 30 days. 30 days from the time that we write, the copies go off. And if they go to the library, and it comes in 1 day after they go to the library, we're going to say, sorry, too late, you must send more copies.
Okay, they send applications before they send their copies.
That's not covered in the decision yet.
Okay, well,
That may be okay, I don't know.
yeah.
It's,
Well,
it's with,
I have a
I'm
letter
having
on my
harder
desk.
time with that one because it's supposed to be, we have a right to just take the copies and send them to the library, but we don't have the right to do something with when we've got an application. So they may be okay. You might tell them we don't have any decision on anything like that yet. Steve?
Are fabrics considered three-dimensional materials then?
No, and in fact there's a special provision for fabrics in here, and it basically wants the swatch of the fabric. And if it's got a repeating design, they want the design repeated 2 complete times, something like that. If you read these regulations, they almost sound kind of funny. There's a special provision for holograms. We want precise instructions on how to use the work. I know there's a thing about fabrics, but I don't see it right now. But they did decide that they really did want the fabrics themselves if they could at all get them. And we're still going to get those. But I can't find it in our regulations. Yeah, Ed.
Videotapes will be used as copyright.
No, I don't. We are going to accept videotapes. I don't know about, I don't know what's it.
Concerned about the connection.
I don't know. You ought to, the general counsel is the authority. I don't know whether we will or won't. Everybody have one of these? Let's just take a TX and work through the second one to see what it would look like. We've got a guy who's a citizen and domiciliary of the USSR, and he's currently serving as a visiting professor of philosophy at Ward Institute. While there, he completed a brand new edition of his book entitled Philosophy, a Definitive Study. He laid his pen down on March 17, 1978. This is a new work which contains about 50% of previously published material, and that was published in Russian in 1976. January 5th, he offers his work to Mead Publishing, a U.S. firm. And on January 18th, the professor signs all rights, including copyright, to Mead. The document was signed by the required parties. Mead then specially commissioned Mariana Jones to translate the work into English. Mariana signs an agreement to the effect that her contribution was made for hire. She finished the translation on August 31st, 1978. The work was manufactured and first published in the United Kingdom on December 3rd, 1978. Let's see how this application would or should look. That nice easy fact situation. I have done away with my TX form. Okay. First one would be the title of the work here. They'd give very simply Philosophy, a Definitive Study. There's no alternative titles that you know about, and it's not published as a contribution, so that's left blank. Now, the authors of the work. Who probably would be listed as an author? Nobody. Who? Okay, Vladimir definitely is an author. And so let's list Vladimir first. So you'd have Vladimir Nabavlovich listed first. The question, was this work made for hire, would be answered no, because he did not do that for hire. He would have an option, or if they knew when he was born, they should put it down. He's still alive, so that's left blank. Then they say author's nationality or domicile. What would they put? Yeah, right. If he's a citizen of the USSR, probably also domiciled here. A visiting professor intends to return back home. And a domiciliary is somebody who is here with the intent to remain. Then it goes on to author of. What would you put for author of? Probably can say just text. Okay. And then anonymous, pseudonymous, you don't really know this, probably no to both of those. There's a second author. Who's the second author? Is Mariana really the second author? Okay, Mead is really. Marianne wrote it, but she wrote it as an employee for hire, and there was an agreement in writing, so it really can be one. So there would be something like Mead Publishing alone, or Mead Publishing as employer for hire of Mariana Jones. They would check that this contribution was made for hire, yes. I assume that they are a U.S. citizen because they are a U.S. company. That would be filled out, and it would not be anonymous or pseudonymous. So there'd be 2 authors. The year in which the work was completed, when would that be? 78. It's all done basically in 78. He puts his pen down on March 17th, and she does the translation on August 31st. And so August 31st is really the one, but all you want is the year, so it's 78, Victor, of, where Mead is. Mead is the author of translation. And if they didn't put that down and we couldn't pick it up from the copy, we'd write back and ask them to describe the nature of their authorship. With respect to the date and month of first publication, they would put that it was first published on December 3rd, 1978 in the United Kingdom. Then they'd have to put the name and address of the copyright claimant. Under what I said we probably would define a copyright claimant as, who would be the claimant? Yeah, it would be Mead, because I said he gave all rights, and they have rights because they're an employer for hire, so they pretty much own everything. So Mead would be named as the copyright claimant. Now Mead is an author, but the way you do line 4 is anybody, it has to agree basically almost exactly with space 2. So they'd have to show that they did get rights from Vladimir by transfer of ownership or by assignment of copyright. They could probably, it says, if the copyright claimants named here are different from the authors, and you've only got them as an author of one part of it, so they would have to explain how they got Vladimir's contribution. And I don't know how that's going to work in practice or what kind of problems that's going to cause. I just see horrendous things coming in. Okay, they would have to fill out parts of the second page, definitely. We don't know whether he previously registered his Russian material. Let's assume that he didn't, so that previous registration is blank. But there is pre-existing material. Half of the book, basically, half of his contribution was previously published. So you'd have to show something like the 50% of, I guess, or half of the material was pre-existing, or 50% of the text was previously published. 50% of the Russian text, you might say Russian, was previously published. And the new material is the translation and 50 additional % of the words. And what kinds of statements are going to be accepted, that will have to be worked out. Basically, whatever is accepted today will be too. Then they'd have to give the names and locations of manufacturers, and these would be British companies, I assume. I said it was manufactured in Great Britain. And then they could give a license if they wanted to, and they'd sign it. But that's pretty much how they'd fill it out. It was just basically to show that you will have half works made for hire and half not. In something like this, probably the text has a term of life plus 50, and the work made for hire thing has a term of 75 years from the date of first publication. And there'll be 2 different works in something like this. Anyone have any questions on that example? Bruce?
As now, only accept registration with the claimant name the same as the claimant was in the notice?
No. No. Remember, today, copyright is secured by publishing, and you have to have the name of the copyright owner in order to get a copyright. So today, when they tell us that the name is wrong, we tell them, well, we can't register your claim, and they come back and tell us that that name was really right, and then they do a document showing the right owner. But we'll only register in the name in the notice today. Not so under the new law. Under the new law, we'll register in anybody's name who's the correct owner. It won't matter who's in the notice. If we can't trace it very easily by the form, then we probably will write to make sure the application form is correct. In other words, if this had a notice in the name of Vladimir Nabalblovich, and it had a good explanation of how this publishing company got the rights, we wouldn't even bother to write. And we're going to register claims, and we are not going to annotate any of those kinds of things. We're just going to let them go. We're not going to say, in notice, Vladimir Nabalblovich. You're just, you've decided you're only going to catalog from the application and not from the copy, and we're not going to cast all kinds of aspersions on what's on the copy if we don't have to. A lot of stuff isn't going to agree. Anyone else? Okay, let me just do the third one, which is a CA form. If you had somebody whose name is Mitchell Ayers and he writes a novel entitled My Little Dingbat, which is all about his wife, and he copyrights it on May 15th in unpublished form, listing himself as sole author and sole claimant. And then he tells his wife about this neat novel, and she gets very upset. She doesn't want that title. she wants him to call it the love of my life, and she wants it correct in the Copyright Office records immediately, he can do that and make her very happy. All he has to do is get a CA form and fill it out. And what he'd do, very simply, is get a CA form, not send us any copies, just $10. And he'd have to give the previous facts. He'd have to give the title of the work as it was, My Little Dingbat, with the registration number, TXU 5432. The year of registration, I didn't give you. He'd have to put down whatever it was. The name of the author, which would be he, Mitchell Ayers, and he would be the claimant, and that would be listed. And he is actually adding additional information, and it's not necessarily incorrect at the time it was made, so he technically should go to space C. But if he goes to B, we're not going to worry about it. In other words, you go to B where something on the application was wrong at the time it was done. But he also can use B. He can use either one. So he technically can say either at B that the old title or the incorrect title, he can say it was incorrect even though at the time that was what it was My Little Dingbat, and the corrected information is the love of my life. An explanation: my wife didn't like the work I wrote for her and wants the title changed to correctly reflect our relationship. You won't pick that up. He could also say, he could also just merely go down to C, new title, and just put the new title down there. And the explanation he could leave it out if he wanted to. But that's how you put new titles in the form, and he'd have to fill the whole thing out and certify it, whatever. So that kind of fact situation will come here. How we found out, by the way, that the author's registration was going to be a problem was I used this for a workshop in New York for book publishers. And number 4, there was an error. Number 4 has a company registering a book entitled How to Cook for Your Pet. And it listed itself as the sole author and claimant, and they register a claim saying that they own everything. But the truth of the matter is Joyce Daly basically wrote the book and they substantially edited it, and they claimed they should have only claimed in the editing. So Joyce Daly wants to correct the basic facts. And I have her using a CA, saying that line 3 was really not right because it said they were the author of everything, and in truth, Joyce Daly is the author of the basic book, and the company only is the author of the editing. And the second alternative in this fact situation was she could go back in and do a basic registration. And the general counsel couldn't figure out under what she would deposit, how the application form should be filled out. And that was how we realized we had a problem in allowing the author to make a second registration. It sounds good in theory, but the mechanics of how you do it are very hard. And that was back in October, and we still haven't worked it out. Yeah.
Our date, correct? Copyright Office date.
It's the date that we register the claim.
Okay, and effective date is something different. Creation.
No, the effective date is going to be the date of the registration. In other words, the effective date of registration is going to be the date of registration for our purposes. And whatever date appears up on the form is the date that they're supposed to give. If it's an old application, one of the E's or A's, they're supposed to give the last date on those boxes. If the application came in on one date and the copy came in another date and the fee a third date, they take the last one, and that's the right date. But it really is the effective date of registration.
So
it's the year.
they're the same thing, the effective date and then
Right.
basic registration date.
Right. Anyone else? You have no more questions. I know it's very discomforting that a lot of decisions have been made, but a lot haven't. And a lot's going to be happening in the next 3 weeks. And as it happens, you'll find out about it. All I can encourage you is, as announcements do come out, and as regulations do really become final, try to read them and get a feel for them. And we are developing kind of practices, certain questions with answers to them, and as soon as they're available, everybody will be getting them. But we can't let them go until we have our registration regulation, which has all of the key information in it. Same thing with the deposit regulation. But they will be done before December 31st, okay? No other questions? Thank you, and have a nice holiday.